Hey guys, Brooke and Laura here for Legal Talk Tuesdays, and we have been talking all about divorce this month. So this week we are going to talk a little bit about the process. We're going to give you an overview of the divorce process here in Arkansas. We recognize, this is a difficult time. It can be really overwhelming. So we hope we can break it down enough that you have an overall picture of what that looks like for you. One thing that we need to tell you is the timeline. We get asked that question a lot. How long is this going to take? And that really depends. It's going to depend on a lot of things. So it's going to depend on your spouse. It's going to depend on you. It's going to depend on the judge, the county, the court that you're in. So there's a lot of variables that we can't necessarily predict. What we can tell you, though, that is in Arkansas, there is a minimum 30-day wait to get a divorce. That's not necessarily the case in other states, but in Arkansas, the minimum is 30 days. And if your spouse doesn't agree, then there are going to be some other variables at play there as well that are going to make that 30 days longer. So that's kind of the general timeline, and that's one of the biggest questions we get asked when people want to know about the divorce process, because none of us want to drag it out.
Exactly. And another thing that we get asked, because we do help people who are representing themselves in court, is that, what kind of documents do I need? What types of things would you prepare for me if I hired you? And there are quite a few documents, and it kind of depends on your situation, whether or not you have children, as to what documents you'll need in order to go to court. The ones that everyone will need, you'll need a complaint, obviously. And every county is going to have a cover sheet of just information that is required for their own record keeping. So address, phone numbers, that kind of thing for both you and your spouse, because whether we like to think of it or not, a divorce is actually a lawsuit. So you're suing your spouse for a divorce here in the state of Arkansas. So it's got a cover sheet that you have to fill out along with you are filing your complaint. If you do happen to have children, then you're also going to have a confidential information sheet, which keeps the children's names out of the public divorce papers. Mm-hmm. You'll have to have help me out here a little bit. I'm still recovering from being sick this last week, so financial means. So you'll depending on the county, and especially if you're a parent and there's any kind of child support or alimony involved, you're going to have an affidavit of financial means, which is about a 7-page document that is kind of a fill-in-the-blank document that's provided by the state, and basically gives you kind of a checklist of what your debts are, what kind of income you have, how frequent it is. Right. And that's kind of how they calculate child support, but it's also how they do a lot of things here in court.
And it's really helpful also when you're working through the affidavit of financial means sheet for you to be able to see what all assets and debts you have and to work through those because, again, it's an overwhelming time. So a lot of times we recommend that our clients, take that sheet and sit down with their spouse. That way you can kind of figure out who's going to take on what, where certain assets are, and you have a holistic picture, not only to give the court, but also between the two of you to negotiate.
Exactly. Things. You're also going to have a summons because your spouse is going to have to be served. Some counties provide that summons for you, some don't. So that's something that we can prepare for you as well. We also, depending on the situation, if your spouse is going to agree, if you guys have agreed on everything before you're filing in court, you would need a waiver and entry of appearance for your spouse. That is something that we can also draft for you. You're going to have an affidavit of service. So along with the summons that you're actually going to have to serve your spouse with, you have to have an affidavit of service that you then take back to the court and say, look, I promise I served that person. The judges are in Arkansas, depending on what county you're in, but pretty much all of them are very strict on certain types of rules. Service is one of them. You have to verify that that you've served your spouse with those papers, and that's something we'll talk about here in a second. But you also, along the way, once you get towards the end, you're going to also need your draft decree of divorce, and that is likely going to include, depending on if you own property or have children, it's going to include a property settlement agreement, and that doesn't necessarily mean that you have a home that you're figuring out what to do with. It could also just be, personal property, cars, things like that, debt, things that you've agreed that one party's going to take or the other party's going to take. But a parenting plan, and those can be really detailed. Talking about custody, visitation, holidays, things like that. And then those are things that often need to be adjusted after you actually talk to a judge.
Well, and that's why it's so important. A lot of these things, just to be honest, you can do yourself. But the problem is people will even come to us and they've gone online to get documents, forms, and what they've gotten has been not state specific. Like we said, we keep saying in Arkansas, we say that because Arkansas has their own rules when it comes to divorce, and all the other states do too. So, your forms and documents may not be specific to our state. And another thing that happens when you do that, you don't necessarily have all the documents you need. We have people come to us and say, I took this document up to the, county clerk, and the circuit clerk won't let me file. And the problem is they've gone online and they've done a really good job of completing their parenting plan, for instance, or a property settlement. But what they don't understand is you have the summons, you have the complaint, you have all these other documents up front that you have to file. And so, we really try to make it easier for you so that way you know exactly what documents you're going to need, and we handle that part for you, so you can go do those things.
Exactly. It's one of the, we see it all the time where with these documents that are required to be Arkansas specific, things like we talked about last week with grounds for divorce. Irreconcilable differences is not a ground for divorce in Arkansas. So if you try to turn that into a judge, they're going to kind of laugh at you and say, they may not laugh at you because that would be rude, but they're going to say, that's not a valid ground for divorce. So having things that are Arkansas specific are very important. Brooke is a military spouse, and we've had people who come to us with online forms that they filled out and paid a couple $100s for, and they're a military spouse, and it doesn't say anything about them being a military spouse. And that is something that you have to have in your documents, especially if you're talking about needing, retirement benefits or something like that. If you're the spouse that's not in the military,
those things, yeah,
exactly. Large list of documents that you kind of need on the front end, but also things like waiver, affidavits of service, the decree itself, which can be fairly detailed and should be fairly detailed, especially if you have children or a lot of debt or property. Those are things that that an attorney can help you with here at MyVirtual.Lawyer or just anywhere. But let's talk a little bit about the overview of the process. Once you have the documents that we've talked about, especially the ones that you need for initial filing, you're going to file those documents with the court. And depending on the county that you live in, it's $165 to $185, somewhere around there, depending on the county in Arkansas, to file your papers with the court. So you have to make sure to budget for that as well. If you're paying a retainer up front to an attorney, they do deduct that most of the time, but that's $2,000 or $5,000 retainer that they're deducting that from versus you just going to the court and giving them $165. So keep that in mind. You have to have all those papers. They won't take your documents if you don't have all the proper paperwork. Some of them can help you with like the generic form, like the cover sheet, for example.
Right.
The clerks can help you with that. But for the most part, if you don't have it, they're just going to say, hey, you don't have this, you need to go get it and come back at a later point. Yeah. When you file, a lot of people are also surprised when your filing is accepted and it gets assigned to a judge in the county that you live in, then you're going to likely, it's not all the time, but likely you're going to get an automatic restraining order that's issued, and people get very surprised by that. It's not the same thing as a restraining order.
That's what it's titled.
It is titled
restraining order.
It's titled restraining order, and most people kind of freak out about that and think, oh my gosh, the police are involved, or it's a restraining order kind of like you would get in a domestic violence situation or something like that. It's a standing restraining order that is issued commonly by judges as an automatic thing in a divorce. Sometimes you have to ask for it, but all it does is really say that while the divorce is pending in that court, while it's going on and before it's final, it stops either spouse from selling property, giving things away, taking the children, if you have children, out of state without permission of either the judge or the other parent. So it just basically means y'all got to keep your stuff here and you can't get rid of things while this is going on. Because the judge at that point once you file for divorce, the judge is kind of the ruling person.
Right.
They get to decide everything. So they want to make sure that you're not going willy-nilly off and selling your cars and your houses and things,
Right.
getting rid of things or taking the kids to another country, something like that. So the standing restraining order, don't freak out about that. It's a common question that we have as well. It's not anything negative. It's just saying, hey, you guys can't do anything to get rid of things or, make life harder for everyone involved, including the judge, because the judge likes to have things as easy as possible when it gets to kind of that.
And I always tell people, just, be aware that that's going to happen. And if you and your spouse are getting along, make sure they know they're going to get that, so they don't think you're just trying to blindside them with something.
Exactly. It's always a good idea to let people know, right, especially if something can be a little bit shock and awe on the title. So after you file your document, you're going to have to get service on your spouse. Service is a required thing in Arkansas. There are specific rules about it, and they've changed a little bit this year. So in 2019, they've changed to where typically in the past, you've been allowed to send the papers to your spouse via regular postal service, registered mail, return receipt requested, restricted delivery. And they allowed for that service to be valid if someone over the age of 14 in the household accepted the letter. That has changed. So in 2019, you have to, if you're going to do it by the postal service, you have to have restricted delivery, has to specifically be for that particular person, your spouse. That's going to cause a lot of problems. And so I think going forward, we're going to tend to recommend that people hire a process server because that's just the easier way. It's a little bit more expensive, but you're not going to have the same problems. And love the postal service, but it tends to be hard to catch somebody who works, for example, at home
or
at
who is
3 o'clock.
evading your service.
Or who is evading your service at home at 3 o'clock when the mail is delivered. So process server is probably going to be the way to go from here on out.
Right. And it's part of that, after you've, gone and filed, you have made service, a few different things can happen. Either your spouse is just not going to respond, your spouse is going to file an answer either by themselves or they're going to hire an attorney, or they've already done the waiver that Laura mentioned in the documents earlier, saying that they agree and you can move forward. So just know that there are different paths, and so that's why it's different and every situation is unique. So we have to individually let you know what you need to do from there. And then after that happens, different things, again, can play out, but the way that it usually is resolved is you are going to have a hearing. And if it is contested, you are going to have a longer hearing. You're going to have a hearing where both parties are represented either by attorneys or they're representing themselves in court. If it's uncontested, you still, a lot of times, are going to have to go to like maybe a 10-minute hearing. That can happen a couple of ways. It can be in the judge's chambers. It can be kind of what we call cattle call, where everybody has to go in there at the same time and you're called up, or you can just go in there individually, and that's going to depend on your court and your judge. And a few judges actually in the state will allow you, if you are in agreement and have all the, again, why it's really important to have all the right documentation, but if you're in agreement and you have everything set up, some judges in the state will allow you to give your testimony written, so you can provide it that way. But just know that there are different things that can happen after you've filed. You also, one thing that we didn't really talk about, just briefly we'll mention because we're a little bit over our time, is that they sometimes will require you to go to parenting classes. The judges will order that if you have children in your divorce. In those parenting classes, you both have to attend. You don't have to attend together. I get asked that a lot. And you have to go when it is scheduled at the facility that you're sent to, and it's going to cost you money. That is also going to vary depending on where you go. So that's another fee that you have to consider when you are thinking of filing for divorce, because definitely in Pulaski County, but there are other counties in Arkansas that require parenting classes.
Exactly. So we've gone a little bit over our time, but there's a lot involved with the general idea and kind of the timeline of what happens in a divorce. But a little recap of kind of why you don't necessarily need a full representation attorney. There are two different types of attorneys, of representation really, that we're talking about here. Full representation is somebody who is, an hourly biller. Most of the time it's an hourly bill that you're paying, and they represent you in court. They do everything. They mail your documents. They take your documents to the courthouse, all that kind of stuff. Versus a limited scope representation, which is what Brooke and I here do at MVL in Arkansas. If you're in agreement on or general agreement and just need to kind of figure out what your options are, maybe have another conversation about what you're going to do with a house or with your kids, that kind of thing, there is not necessarily a need for a full representation attorney. Most people are competent enough to be able to follow instructions. Mm-hmm. With a limited scope representation attorney like Brooke or I, that we can prepare your documents, make sure that everything legal is, all the checks are, check boxes are checked and the T's are crossed and I's are dotted. Make sure that you have everything you need to have, along with instructions for the whole process. And it makes the whole process more affordable, is what it does. So with limited scope representation, you're doing administrative tasks that you don't necessarily have to pay an attorney rate for someone to do for you, which is very helpful for anybody who doesn't really want to, be charged an arm and a leg for
mailing a letter.
For mailing
like you were talking about earlier, you're going to add the time spent to go prepare it and take it to the courthouse, as opposed to just going and paying the filing fee yourself.
Exactly.
For sure. And then also, another thing that we do is offer instructions on what to do. So, it is something that you can do alone. It's something that you probably, based on all the stuff we threw at you, need an attorney to at least guide you through. So you're able to get the services that you need with limited scope, but not necessarily, things that you can do on your own. You're able to do it within budget, and you're able to have somebody walk with you along the way to tell you what to do.
Exactly. And with a limited scope attorney, I'll just mention this briefly. Yeah. With a limited scope attorney, especially here at MVL, we don't just prepare your documents and send you on your way. We are your attorney for that limited matter of helping you represent yourself in court. So if you have questions along the way, if things, during that 30-day waiting period, or if your spouse doesn't sign the waiver, that kind of thing, you can come to us with questions, ask them kind of along the way. And it's not just a, hey, here's your stuff, go away now. Right. We are your attorney for that limited matter, which is helping you represent yourself in your divorce. And so it's a process that people don't necessarily need to talk to their attorney for 10 hours on the phone. I know you want to, but you don't necessarily need to. And keep in mind, whenever you talk to your attorney in a traditional kind of setting, you're being charged for that. So with a limited scope matter, especially with us, it's a flat fee, so you know exactly how much you're going to pay up front. And keep in mind, average costs in Arkansas for divorce, they can be, $12,000 to $27,000, and that's a lot of money for most people.
And we've thrown out a lot of, and remember, you're going to have to pay this filing fee, and remember, you have to pay this process server. So there are a lot of fees that are included with that, but we try to make that transparent for you here. And this is really not the end of our divorce conversation. This is, again, we could talk forever. We went way over our normal time because there's a lot to cover. And we also mentioned limited scope representation, which is something we're going to work into all of our topics. But unfortunately, January is coming to an end, or fortunately, however you want to look at it. But for February, our theme is going to be children. So we're going to kind of segue into all things children. And next week, we'll be here at 11:30 Central Time, and we're going to be talking about paternity, which is, there's a lot of myths surrounding paternity. So we hope to see you there. Thanks for joining us today and hanging on for our extra long live, but hope to see you next week. Thanks.
Thank you.